And good morning, Graham. All right, so good morning. It's Friday, January 29th, 8:31 a.m. And this is the meeting Senate Natural Resources and Energy. We're continuing our work on picking up on weatherization, and we wanted to spend some time with Mr. Campbell and JFO looking at the revenues. The PUC alluded to them, but most of them weren't quantified. So I wanted us to know what kind of money flows through the current system as we think about the evolution of that system. So Mr. Campbell, I don't know if you're set up to share a screen or how you want to do this, but the floor is yours. Thank you.
Graham, how are you?
Thank you, Senator Bray. I'm doing very well, Senator Campion. It's good to see you again.
Good to see you.
Yeah, I sent a document to Judith this morning entitled Vermont Taxes on Energy. I'm not set up to screen share at the moment because I'm using my iPad.
Okay.
And I haven't pulled it up. So it should be on the committee's webpage. I'm just trying to double check. That's right.
Yeah, it is on the webpage, I believe.
Okay. Here we go. Just needed to refresh my page.
And
Jude, do you want to put that up? So we can, or
I can see if I can pull it up here and maybe try to share it on my iPad.
yeah, let me. So I just opened it. Is it showing over there?
That's showing, yeah.
You got it on my screen.
I'm not experienced enough with this to know how I can also see exactly what you're seeing.
Is it not on our website?
It's on our website.
Okay.
It's also showing up on the YouTube. So
Yeah.
Okay.
I mean, I'm fine, Mr. Chair, unless somebody doesn't have it. It's always great to just follow along with on our iPad, but that's just me.
Okay. If everyone has it, then I'm gonna end this so we can see each other and hear better and all the rest. Okay, great. So again, everyone's got it in the Friday documents folder off our website. And turn it back over to Graham. Are you all set up? So we have it, you can just refer to it.
Yeah, I think that'll okay. Work. Yeah. So I'm Graham Campbell. I work at the Joint Fiscal Office. Just a quick background on myself for community members who don't see me very often. I work on non-property, non-transportation tax sources for the state of Vermont for JFO. And so I will apologize in advance if I don't have very many answers for the committee on non-transportation, non-property types of taxes that go into energy. And it's my understanding that the bulk of this discussion is going to be focused around weatherization. I prepared this document sort of listing out all the various major taxes on Vermont energy. That does not include any fees or any other charges, of which I don't have much information on that. But if the committee has questions, I can take them down and bring it back to the appropriate person at JFO. But I was going to refer to this document, and Senator Bray told me that there was a report from the Public Utility Commission that included some sources of funding for weatherization and for and similar types of goals, and they were missing some of the revenues on that. And so hopefully I'll help fill in some of those gaps. But beginning from this sheet, I guess the tax that's most relevant to this committee is what is called the fuel tax. and this gets confused a lot with what's called the gross receipts tax, because this tax used to be called the fuel gross receipts tax. But I think in 2015 or so, or 2017, it was changed to the fuel tax. And so for all these taxes, I've sort of done the sort of what is it, where does the money go, and how much do we raise? So for the fuel tax, I apologize, I just looked at this. That's a typo. It's not 0.2 cents, it's 2 cents. So the fuel tax is a tax on various energy sources in the state. It's 2 cents per gallon on basically any type of fuel as we traditionally think about it. So heating oil, kerosene, and propane are the ones that are listed in statute. 0.75% on the retail price of natural gas and coal, and 0.5% on the retail price of electricity. And so any of those things that are sold in Vermont is paid and itemized on the bill for the customer. And I believe that tax is submitted monthly by the distributors of these fuels, these energy sources. Where does the money go? All of this money is deposited into the Home Weatherization Trust Fund, which is used to fund weatherization programs in the state. And how much do we collect? I checked to see if I get some updated data for fiscal year 20, but it was not going to be forthcoming by the time I was presenting. But generally, it raises between around $10 to $11 million per year. That might have changed in light of COVID because of lower gas prices and other changes in consumption patterns. But generally, it's about $10 to $11 million per year. And like I said, it depends on the prices of fuels and electricity and the usage. And one thing I wanted to add here is that of the $10 or $11 million per year, about 45% of it comes from the fuels part of this, so the 2 cents per gallon. 45% comes from the electricity, and natural gas and coal is about 10% of the total. There's not very much coal being sold in Vermont anymore. It's very, very little of the actual revenues generated. So most of that 10% is actually just natural gas. So
I have a quick question on well, for one thing, thanks for explaining that the fuel gross receipts tax is now just a fuel tax, because it's been confusing to me to hear two different terms. I didn't know if we had two different taxes or how that worked. Is this sort of an anomaly of the history that part of the tax is collected as a percentage of retail price and part of it is a per unit of sale, per gallon versus percent of cost?
good question. I don't know the answer, although I think I'm just thinking about what I know about this tax. Is I think it has the fuel gross receipts tax was slightly different than this tax, and
Okay.
I think one of the reasons they switched to the fuel tax, and they did change up some of the tax rates here. I think one of the reasons for that was, as you're suggesting, where the fuel tax might have been subject to price changes a lot more under the old system. But I think what you're hinting at is correct in my vague recollection of how this works. But I'll look into it, into why those are, or what the old fuel gross receipts tax was and how we changed it over. I'll confirm that.
Thank you. I mean, I know we've had just a touch of a conversation about thinking about perhaps simplifying or modernizing or having these taxes evolve in some way. But all right, thank you. Well, Senator McDonald, you've been there for most of these twists and turns.
Following the recession of 08, 09, fuel revenues were down from all the weatherization monies, and a change was made to go with the percentage of the cost rather than the number of gallons. And in exchange for that, the lobbyists for the fossil fuel industry was able to get the tax put on the bill. It used to be a tax that was in the bill on the bills that were sent to the buyers, and we underwent a about a year and a half of, why, there's new taxes, and from constituents. But it was, the change was made to deal with the '09 recession and lack of sales, and to boost the weatherization and try and keep it whole around the same number of dollars.
Thank you. Okay. And I think there is also too, I don't know if you came across it, a petroleum cleanup fund assessment. So I don't know if that's.
There is. I don't know a whole lot about that fee or that fund, but there is an assessment on that is on the same tax form as the fuel tax, and it raises, I think, about $1.5 million a year.
Right.
So.
Okay. All right. Senator McCormick.
Thanks. Am I correct that the petroleum storage tax, that is paid by handlers, it's not paid by the public, is that right? It's like more of a premium than a tax. They're paying into a fund so that it's there if their tanks leak.
It's more like an insurance plan.
Yeah.
That's my understanding as well. It's a distributor sort of licensing fee, not paid in the same way that the fuel tax is, where it's itemized on the bill for the final sale.
Thanks.
Okay. Any more questions in this first section before we get to gross receipts? Okay, thank you.
The second tax that I wanted to bring up here, and this was in Senator Bray sent me a report, the Act 62 report I'm looking at here, and it contained current and proposed funding. It has the gross receipts tax on there, and what I think they're in that table is they're confusing the gross receipts tax and the fuel tax. There is a gross receipts tax. There's the fuel tax, which we just discussed, and then there is a gross receipts tax, but it doesn't fund weatherization. Well, perhaps it does in some indirect way, but we have a gross receipts tax in Vermont, and it's basically on entities that are under the purview of the Public Service Department and the Public Utility Commission. And basically the money from that tax is used to help fund the departments. So it's on not just like energy, but other things. So it's a tax of 0.00525% of gross operating income for electricity companies and cooperatives. It's a 0.005% operating revenue gross receipts tax for telephone companies, 0.00525 for gas companies, 0.001% of gross operating revenue for water companies, 0.005 for cable television, and then for any other entity that comes under the purview of those two agencies, it's 0.001% of gross operating revenues. And so that currently exists. It's separate from the fuel tax. I believe my understanding is that it's quite separate from the weatherization fund. The fuel tax is the one that does the weatherization fund. The gross receipts tax is the one that funds the Public Utility Commission, the Public Service Department. But all revenues from this tax are used to fund those two agencies. And we collect about $8.5 to $9 million per year on that one. And I believe I'm trying to think, a couple of years ago, a couple of these tax rates were boosted a little bit because this funding stream has had trouble keeping up with the cost of the department. And so it was changed, I think, a couple of years ago to sort of make up that difference. So we're generating about $8.5 to $9 million, maybe a little bit more once that change has gone through. But that was the latest data I could find for this morning.
Great. Thank you. So that's the regulated community paying for the regulators, basically.
That's my understanding of how this works. Again, I don't have a whole lot of knowledge on this specific tax, but yes, that's my understanding of how this one works. It's not, the money does not go into the weatherization trust fund like the fuel tax. Most of it, I'm assuming, is used to help pay for the regulating agencies.
Okay, and this one is a true gross receipts tax, correct?
Indeed, yes.
Okay,
Yeah.
got it. Thank you.
And I want to sort of note that these tax rates you'll see are not exactly what you'll see in statute. There's actually two separate tax rates in the statute under, I think it's entitled 22, which they're separate tax rates, but there's one for the Public Utility Commission, there's one for the Public Service Department. I've combined them in this document. So, just in case the committee's looking at the actual statutory reference here, you'll see these are a little different, but that's because I'm just combining the two of them.
Okay.
To make it easier.
Thank you.
Um,
Senator McCormick, do you have a question? No. Okay, thank you. Anyone else before we go on? No? Great.
Before I jump over to some of the transportation taxes, I just wanted to mention also going back to the fuel tax, that there was a proposal that passed the House 2 years ago, H 439, which would have doubled the fuel tax part and the natural gas tax part of the fuel tax. And I can't quite remember how much revenue that was going to raise, but it was essentially an attempt to raise money for the Reorganization Fund. It passed the House and did not go anywhere in the Senate.
And sorry, did you say H 439?
H 439, yes.
Yes. Okay. Thank you.
So there has been a little bit of legislative action on the fuel tax of late. Oh, and another thing that was in a recent miscellaneous tax bill, I think it was 2 years ago, was a specification that nonprofits would need to start paying the fuel tax. So there was a clarification on the fuel part of the tax that it was 2 cents per gallon. I'm trying to remember the language, but essentially on the sales to a Vermont or by a Vermont business or to a Vermont consumer in a Vermont business, and nonprofits were saying we're not a Vermont business, we're nonprofits. And so the statute was cleared up to sort of make clear that it was to deliveries of any consumer, business, or nonprofit. So that was another change to the fuel tax that did pass.
All right. And I seem to remember in that same discussion, there was a question of whether or not it applied to municipalities, right?
Right.
And agriculture came up, and forestry, and
Right. I believe when it passed the House, there was a floor amendment that would exempt the fuel tax or exempt farmers and timber operators from the fuel tax, and that passed on the floor. That was part of H 439, and I can send the committee the fiscal note for that, just so you have it for reference.
That'd be helpful. Senator Campion.
Mr. Chair, when we're talking about the work that we might do for weatherization, would we be funding from taking, the resources that we have, all of the funds, taking, however we're working, and then putting in additional sort of one-time monies, if you will, or spreading out, taking money from the general fund? Is that what we're thinking? Over a 5-year period?
We could go, personally, I'm not settled on what's the best way to address it. I just wanted to understand the current revenues, because they seem to confuse a lot of people. And
no, I agree. I was just curious what some of our options were, in other words, to get to the dollars that we're going to actually need.
Right. So, Miss Bob Barton yesterday went through like 6 different ways to raise money. So some of those are entirely new to us, and we'll have to partner with finance to really get that work done. But my hope was that we would look at the revenues we already have. Mr. Cota had suggested, maybe combining things. So I don't know if there's some sort of rationalization of what we do now. It does seem like, whatever. It's kind of a collection of taxes that's, it may be perfect the way it is, but maybe there's room for improvement. But the PUC also proposed a new fee, basically the thermal energy benefit charge, which is, I think of as the delivered fuels counterpart to the energy efficiency charge on an electric bill. So that's an option.
Well, that's helpful. It's a good review. I
Yeah.
appreciate that. Just trying to get some more of an understanding of finance.
Yeah, I mean, I think we have many options in front of us, and the question is going to be assembling them over time. Okay. And just before we go over to transportation, and well, Grim, I don't mean to cut you off if you want to say more on the other stuff, but I talked to Senator Westman just this morning about transportation again, to your point, Senator Campion, and there are, although we're focused on weatherization at the moment, there's a real natural connection, especially for low and moderate income folks that we're targeting for service through weatherization, that transportation is also one of their biggest challenges, and at the same time, one of the biggest sources of emissions. So I don't want to lose sight of an opportunity to perhaps work on both in concert. So that's why we have transportation taxes in here, not just weatherization. All right, Mr. Campbell, back to you.
Thank you very much. I would preface this by saying if there are any deeper questions about the transportation taxes, I'm going to forward them to Chris Roop, who's our transportation analyst. He works with these taxes, and he was unavailable to be here this morning due to another committee commitment. So I'm going to run through them just for the committee, but we have a gasoline tax and an assessment. It's essentially a 13.1 cents per gallon tax plus a variable gasoline assessment of approximately 4%. That's what Chris told me. And it's subject to a floor and a ceiling. So the floor is about 13.4 cents per gallon and a ceiling of 18 cents per gallon. And it kicks in at various price levels. So the floor kicks in at about $3.87 per gallon, and the ceiling is, applies when prices exceed $5.08. So Chris told me we've been basically operating at the floor for a while now. Where do all the monies for these go? Basically to the transportation fund. And we are projected to collect about $67 million in gasoline taxes in fiscal year 21. That's down relative to its previous January 2020 forecast due to less driving in the pandemic. The diesel tax is a 29 cents per gallon tax, and 28 cents of the diesel tax goes to the transportation fund, and 1 cent of the diesel tax goes to the petroleum cleanup fund, similar to the distribution fee. And then we have these transportation infrastructure bond TIB assessments and taxes. So there is a fixed 3 cent per gallon tax on the sale of gasoline and diesel, and then a 2% gasoline assessment. And all the monies for those go to the TIB fund, which funds certain long-lived transportation projects, including bridge, roads, and culverts. And we're estimated to collect about $12.6 million in TIB monies this year. So if there are any questions on those, I can defer those to Chris.
Right. I think Senator Westman worked on the TIB one. So is this a revolving loan fund? And if that's not a question that you can answer, Graham, Senator Westman, I think, knows this one.
Yeah. It was set up, and the reason it's the 2% assessment is it's before you get to the pump. And what it allowed us to do is set up a bond fund that we could match for borrowing, and that they didn't go against the bonded indebtedness of the state. So it doesn't affect the ability of the capital bill because it's a separate standalone fund.
Great, thank you. Well, one more quick follow-up question, just so I understand the scale of it. So 12.6 million comes in 21, and that services the debt on the bond. Is that, I mean, the interest on the
Actually,
bond?
Actually, we've done very little bonding with it, but what it allowed us to do is match the federal money coming in. And so, for example, during after Irene and with the federal stimulus money that came in after 2008 and 9, we used this fund to match federal dollars to be able to do that. So we've done very little bonding with the fund as was originally intended, but we've used the money directly. But there is the ability, the way it's structured, to do that.
Okay. Senator McCormick.
I think, Rich, is it because of the federal funding that this does not count against our bonding, our state? I mean, we're paying off the bond, at least in part, with Vermont tax dollars, right?
No, it was because it was set up as a totally separate fund with somewhat of a fence around it, and the gasoline assessment is before you get to the pump. So it was a completely new revenue source, and because it was a completely new revenue source, the bonding agencies allow it to be considered outside of the general bonded indebtedness of the state.
Neat trick. Thank you.
Yes, and it took, what I will say to you is it took 3 times on the floor of the House getting whipped before we could get this through.
Senator McDonald.
So, thank you, Senator Westman. Is it correct that the tax that was collected from the distributors of this fuel added to the tax that users pay at the pump? Was the purpose of this because when gas prices got very expensive, people used less gas and revenues declined, and this bifurcation of the collection was designed when the price went up and tax dollar and revenues from per gallon declined, this taxes the price of gas, which would then, instead of having peaks and valleys, would try and level it out so that it was a more steady collection under both circumstances.
If you look back up at the gasoline tax in the assessment, the 13.1 cents, where you have the 13 and the 18, and you have the 4% assessment, I would say to you that specifically that was done to create that balance that you're talking about, because during the recession, the per gallon amount dropped dramatically, and that was all done with an eye towards spreading it out so you wouldn't have the peaks and valleys that you're talking about. In the Tib Bond Fund, there was an adjustment made to recognize some of that, but the original reason for the 2% assessment was that it was a new tax, and it allowed us to set up a fund that we could bond against. And it was really that bonding piece in the Tib Bond Fund that created that, because we couldn't bond in transportation without it affecting the general bonded indebtedness of the state. And this allowed us to skirt out around that. Well, no, I take that back. It allowed us to do that because we're not supposed to talk about this. It's one of those things that we're not supposed to talk about, even though that's what it did.
But it did take out the peaks and valleys.
But what you're looking at, the 4% with the variation for the 13 to 18 cents, and that specifically was designed to do exactly what you're talking. It spread it out across the fuels in various ways. Because when the consumption went down, the price went up of the fuel. So it allows you to collect almost like a sales tax on the gasoline, and did exactly what you're talking about.
Okay, I thank you for explaining that. It was complicated, and you guys solved a big problem on transportation when you did that. Thank you.
Great. Right. Any more questions for Mr. Campbell?
I just want to mention one more thing here. As I was looking at some of these transportation taxes and thinking about, Mr. Coda and some of the testimony I've heard from him regarding the fuel taxes, there is a potential for not confusion, but there is the diesel tax, which is paid on-road diesel fuel when you go to the pump, and it is not dyed. It's clear diesel fuel, and that pays the diesel tax. And then the fuel tax, that's on dyed diesel fuel. And so that dyed diesel fuel does not pay state and federal highway taxes. It is for off-road uses. And so the fuel tax gets applied to the dyed diesel fuel, but not to clear, normal on-highway diesel fuel that's used for cars and SUVs.
So are you saying back up in that category of heating oil, kerosene, and propane, we should also add dyed diesel?
Yes, dyed diesel fuels are in there. Yeah, that
Okay.
should be added.
Okay, great. All right. This is, when you first hear about this, it seems like a very simple idea, tax fuel. And then when you walk through it, there's some intricacy.
So what isn't mentioned in the diesel tax, and I can't remember exactly how it's administered, is we have an interstate agreement, and the interstate agreement, I think virtually every state, and I think all of the provinces in Canada belong. So if you, the reason the truckers keep travel logs and have to log that in with their home DMV is they end up paying the fuel taxes. And it's not at the pump.
I
Say
don't
that
know
one.
the specifics about how on
I-
the transportations, but I can.
I can't remember, I think it's IFTA. So, but the big trucks that you see rolling through the state, they do pay the fuel tax.
Okay. So, Mr. Campbell, could you tune this up just a little bit to like fix that typo, add in the dyed diesel thing? I know that you were working with little time and outside your regular bailiwick, so no problem. We'll tune this. The other thing is, could you add in exemptions? Like there were questions about forestry and agriculture, school buses came up, municipal fuels. You mentioned nonprofits. It would just be helpful to make sure we know if there is anyone who's excluded, what they are too.
Yeah, so I'd say there's two types of exemptions. So or two types, but we have the fuel tax here for weatherization, and there's not a lot of exemptions on that, if any. There might be some for state and local government, but there are, amongst other types of fuel, there are exemptions in there. So, for instance, residential purchases of energy to heat a home or electricity are exempt from the sales tax. So is that something the committee is interested in seeing, or are you looking more just at the fuel tax?
I was thinking of it just the fuel tax.
Okay. I'll check to see if there's no formal exemptions in statute. Like it doesn't say these people do not have to pay the fuel tax, but the definition might exclude some groups, but I can look into that, but there won't be very many for the fuel tax itself.
Okay, great. All right. Well, thank you very much.
Thank you.
So with that, we'll change gears here, and we're going to look again. We discussed earlier in the week the executive order on the reorganization of the Natural Resources Board and the district commissions, and people wanted to get a little more testimony. So we're going to return to that topic now and hear from some folks who have offered to speak with the committee to bring some more testimony in from the field, as it were. So with that, I'd like to welcome Mr. Musgrave back to the committee. Good morning. Good to see you again.
You're muted.
Unfortunately, we can't hear you yet. I don't see the little microphone symbol, but I still can't hear you.
That might be his testimony. He might be finished. Thank you, Mr. Musgrave, for coming. We appreciate it.
Sorry.
There we go.
There we go. Good morning.
Senator Campion, I echo your sentiments on this. This is not my favorite appointment of the week. Thank you.
It's nice to see you.
It's nice to see you too. And Chairman Bray, thank you for inviting me to come out. I really appreciate it. And I want to make an apology to the committee. I'm on a personal day off today and I'm nowhere near my tie collection. Otherwise, I would be wearing a tie before your committee today.
Well, you're making us all feel more comfortable just seeing you not choking with a tie on. So
thank you. Well, I appreciate the invitation. And this is, for the record, my name is Matt Musgrave. I'm with the Associated General Contractors of Vermont. And I do feel honored that you invited me in to have part of this conversation with you. The Associated General Contractors, just a brief introduction, is a trade association for the general contractors, road and bridge, as well as commercial and residential builders in the state of Vermont. We have about 15 to 20,000 people that are within our employ who do that work. And one of the things that we focus on and are proud of is that we are recognized by the International Panel on Climate Change that we are one of the few green jobs that exist in Vermont today. So I wanted to start by saying that the Associated General Contractors is conscious of environmental practice and law and believe that the Act 250 process that has been going on over, this has been now almost 4 years since the Act 250 Commission began, is a worthy process and one that should be discussed at great length. And I believe the right venue for that is here at the legislature. Watching the events through the Act 250 Commission and the processes over the last biennium with the attempted rewrite of Act 250, the Associated General Contractors was very encouraged by two things through the process. Number one, we were encouraged by the environmental protections that were looked at within the new proposals. With our knowing that Act 250 was written back in the 1960s and 70s, based around the ski area expansion and sprawl that was going on at the time, we believe that there are new practices that need to be observed within the policy of protections, because the value of the state of Vermont is directly attributed to the beauty of our mountains, the clean water that we enjoy, and the scenic landscape that we all treasure every single day. We were also encouraged by the fact that we saw that there were some attempts to make procedural changes to the process, and that meant looking at how the board operates, and it looked at how the appeals process worked. And the House bill that passed last year had a lot of that built in, and all of a sudden we had COVID hit. And I think COVID, as we all can agree to, caused some major challenges in our processes. It limited us to not being able to meet in person. It limited us to not being able to have some of the robust conversations that we really should be having. regarding the Act 250 rewrite. And I think that we have now an opportunity to, although it may take a little bit more time, continue that conversation on process. So with that, our position on the executive order, without getting involved with the politics of the matter, is that we believe that it is an opportunity to begin a discussion of how the Natural Resource Board, the appeals process, and the Act 250 application process will work. So we would like to be a part of that process going forward. We encourage you to look at the executive order, find things that you can agree with, find an opportunity to have these discussions, and we would like to be at the table while these discussions are taking place.
Thank you. Senator Westman.
I would just point out that the executive order for us is a yes or a no with no changes. So the executive order in itself doesn't allow us to have any real discussion in that respect. So,
and respectfully, I would like to abstain from how the message was delivered and focus more on the content. And I think if I was to make a request today, it would be legislatively, let's look at this.
Okay.
yeah.
Well, thank you.
Thank you.
Yeah, I mean, to be direct and plain about it, I think we've acknowledged that there's work to do, but it's, as everyone knows, it's complicated. And so there's a give and take in that kind of conversation that you're talking about. But I appreciate that you're interested in being at the table. And I think what's really crucial for us, one of the things I feel that, I'll just speak for myself, it's very helpful to hear from people who go through the process and learn about strengths and weaknesses as it exists in the real world, as opposed to just what we see in the whatever 137 pages of chapter 151, you know. So
and we would, Chairman, we'd be happy to bring plenty of people that are within our association that have had experience with this. And I think that's the way that you find a successful law, through as many voices as possible. And if you may remember, AGC signed on with a letter that said that Zoom is really challenging for all of this.
Yes, yeah. It's I think we all agree with you on that one. That's not the ideal way for all of us to do business. Well, let me pause for a moment, because both Senator McCormick and Senator Campion were on that Act 250, the next 50 years, 18-month working group. And what I'm trying to, I don't mean to be putting you on the spot, were this issue about the relationship between the boards, the NRB and the district commissions. Is that something you, my recollection is you have recommendations on that in there, or you at least looked into it. I don't know if you came to firm recommendations, but just things for us to consider.
Well, I will say, if you look at the witness list from the Act 250 policy last year at the House side, I was not involved at all, because we were pretty supportive of the efforts between VNRC and the administration.
Okay.
The thing that comes to mind when we talk about this, and I can read the press like everybody else does, there is a push and pull between local control and statewide control. And I think that big challenge that we deal with, is that there is a subjective nature to the policy. And depending on who you talk to, you're going to hear different opinions on how that works out. And it generally depends on what party are you speaking with? Is it a successful party, or is it an unsuccessful party? And we know that 98% of the Act 250 applications are eventually approved, but that doesn't speak to the applications that are never submitted because they don't pass a feasibility study from the developer themselves. And the developer needs to see the opportunity for a predictive outcome. And when we look at a statewide policy with local control, I think it makes sense, or we believe it makes sense, that with a major decision, that there is some sort of a level playing field across the board, and that a set of rules that people can agree with. And how that looks is something that we can discuss, but there is, I think, a difference, and there is definitely a statewide housing issue. There, I spent 20 years working in the real estate business, and Vermonters are spending a larger percentage every single year of their income to buy homes, to move into a place that they have the opportunity. And now when we have COVID, I speak from experience, I'm looking to buy a home right now, but I'm going to wait 2 years until the COVID migration is over. Prices are extreme here. And we have a huge benefit from Act 250, and that is preserved our environment. It's preserved all those things that attract people to Vermont. But when we look at a statewide policy and how that works locally, I believe that when we talk major projects and not minors, it may make sense to look at something in terms of a statewide board decision. But it's a longer discussion than we can have today in this call.
Yeah, great. Well, thanks for your candor. I think, when we return to it in more depth, personally, and maybe other members too, it would be helpful to learn more about how that inconsistency shows up. What is that like out in the development world, so that we could address that better. Right. Any questions from the committee for Mr. Musgrave? All right. Senator McCormick.
Yeah. First of all, thanks for your testimony. When you talk about the need for some kind of statewide consistency, are you talking just about major applications? Okay. Well, because now
Yes.
a disclaimer here. Any personal war stories I have to tell about when I chaired a district commission is very old information. It's a lot, but we usually could tell at the district level when both sides knew they were going to end up going to the board on appeal, that whoever prevailed, there would be an appeal. And you could tell because they weren't really trying. They did not bring out their best witnesses. Neither side put on much of a show. And the guy was sort of, let's get this over with, and then we're going to appeal, and that's when everything is going to happen. Now there had been discussion of some way to simply go immediately to the board if both the applicant and people who are opposed to the permit agreed. But rather than, I think what's being proposed, as I understand it in this executive order, is that the state board is going to make the decisions with some input from the local.
So my understanding on the executive order is that the minors will remain at the district commissions and the majors will go to the board. And I kind of, when I think about, without citing specifics cases, when I think about in general the process of what people go through, you could potentially be right. I mean, they could potentially be saying, well, you're going to rule against us for whatever reason. It could be a Hatfield and McCoy reason. I don't know what that reason is. So maybe people do just anticipate on going there. And if that's the case, then does that make sense? That's the venue to begin with.
Yeah. Okay. I think there is a difference between different levels of controversy and different levels of ambition of a project. Yeah, and it may well be that some things ought to be dealt with at the state level, but not as a sweeping policy change.
I mean, as a specific case that I would mention, when we regularly see one fuel dealer opposing another fuel dealer from building a gas station, that maybe means that we need to have a discussion about the process. And we see that in Chittenden County now.
Well, that's also the job of the district commission chair.
Yeah.
Is to understand their job is to ascertain compliance with Act 250, not to settle property disputes.
Exactly. And that to the point of the order, I think. And again, I think this is a much larger discussion than maybe what's in the EO.
All right. Well, thank you very much. Yeah, that one, the last one you're pointing to, that one seems, you mentioned Hatfields and McCoys. That one seems like a tough one to solve.
I don't know if I can use that analogy anymore, but I will try.
We never heard you say it. So anyway, okay. So if there are no further questions or comments related to Mr. Musgrave and Associated General Contractors, then thank you very much. Good to see you again, Matt.
Thank you.
You're welcome to stay or go. Since it is your day off, you may want to just go.
I'll watch quietly in the corner over here.
Right.
Thank you.
Our next witness had a conflict on schedule and had let us know he might arrive a little late. So I don't see Mr. Stanek in the room yet. And with that, I'd like to just go ahead then and invite Mr. Groveman up. Good morning, Mr. Groveman. Good to see you again. And you are still muted.
Yeah.
There we
Yes. 2020, you're still muted, right? Now 2021. Well, thanks for having me here. I really appreciate it. I didn't put on a tie, but I do have pants on and a collared shirt. So I feel, I'm going part way to do the job here.
Mr. Groveman, you're still muted.
Very, very funny. So if it's okay with you, I'm just going to launch into some comments that I want to make, and please interrupt me and we can have a conversation about it. Is that a good way to proceed?
Sure. I mean, as you know, we're trying to look at the merits of the proposal and just understand it a little better from, if it were enacted, what does this mean to people out there who are practitioners?
Yeah. All right. So just before I get started, even though I've been before this committee many times, and I know you all, just so the testimony I'm going to give today is informed. I've done a lot of work in the state on various environmental issues, but I think my favorite work and the most work I've probably done is on Act 250. So I speak to these issues as the former Act 250 attorney for the state in the mid 90s. So I think I've been before every district commission from 95 to 2000. I used to practice before the former environmental board. I represented the state in several appeals there. I was the A&R general counsel. So I've seen Act 250 from the perspective of A&R leadership and having to interact with Act 250 and work with the various A&R programs. I had the privilege of being the NRB chair for a couple of years during the Shumblin administration. So I got to see the administration of Act 250 post-environmental board era. So I have that perspective. And I work at VNRC now. I'm the policy and water program director for VNRC. And I have represented VNRC and citizen groups before district commissions and the environmental court. So that's my perspective. I think I have a good range of experience to comment on these issues. So VNRC, as I think you all know, based on our work with the Commission on Act 250 and on the bill last biennium, we do believe that there are improvements needed to the Act 250 process. But we think the need for those improvements really stem from two things. The main thing is the elimination of the environmental board in 2004. We believe that had a significant adverse effect on the Act 250 program. And so we believe that any modernization, updating of Act 250 needs to address the harm that was done to Act 250 when the environmental board was eliminated in 2004. And then we also we also believe that we haven't sufficiently invested in the Act 250 process, like many of our governmental programs over the decades. And we do need to invest more in the district commissions to help them meet the challenges of dealing with complicated applications in the world today and the important issues that they deal with. So I'll deal with both of those specifics. But I want to say up front that while we agree that those are the two main problems, or believe that those are two main problems with the process that does need to be addressed, we don't agree with the the executive orders proposals before you. And we would urge you to, as Senator Westman says, it's yes or no. So if it's yes or no, we would say that the executive order should be turned down, but we still should address these issues. So the two issues that we think process-wise that need to be addressed. So the Environmental Board, and Senator Campion and Senator McCormick heard this as members of the commission, and Senator McCormick has lived this as a district commission chair, and just in all his work on environmental issues over the years. And and Senator McDonald, I think, falls in that same category, just watching the evolution of Act 250, that understands that the Environmental Board was a cornerstone of Act 250 when it was created. So on the process, they were basically, the foundation was made up of two parts. The regional commissions, there was a decision made that we should have regional review of projects that were of a large enough scale to have the potential for regional impacts, but there would be a need to review those decisions, and there would be a need to have appeals of those decisions. And the appeal should be heard by a board that was a state board that had representation really across the state and different areas of expertise. It was a 9-member board, so there was opportunity. The members were appointed by the governor, so it wasn't required in statute, but traditionally the board was made up of different members from around the entire state and of different backgrounds. And so that was really, those two pieces really helped build and grow Act 250. And the board was really vital to that. The board, if you look at Act 250, there are 10 criteria, but there are 30 sub-criteria and criteria when you add them all up. And they don't say very much. They say things like no undue adverse effect on water or air, or not have an adverse effect on growth or scattered development. And these terms were not well defined and fleshed out. And the board, for the first 20, 30 years of its existence, went about issuing decisions that really brought these criteria to life, fleshed out what do these terms mean in the statute, provided policy guidance to the district commissions on how to implement the statute, and provided guidance to applicants and parties about what would be needed to get a positive finding and a permit under Act 250. And if you look at this, there's something called the E-Note Index that indexes all of the decisions on appeal that have made in Act 250 since the history of Act 250. And you'll go back and look, and you'll see the board issued, dozens and dozens of vital decisions on all of these criteria issues, on process issues that are very complicated and in-depth, and really, like I said, it brought Act 250 to life. And what happened in 2004 is we basically severed the board from that process of looking at the criteria, looking at how Act 250 worked, issuing those decisions and providing that guidance, and we moved appeals to the court. And courts just simply are not set up to provide that sort of guidance on policy and how a statute like Act 250 should work. Courts are set up to weigh evidence and look at which expert they believe, because Act 250 has become a statute that relies on expert testimony. And so that's what the court has done. In most cases, they'll say, I believe this expert and not that expert, but doesn't really provide the policy precedent that you see in the E-Note Index if you go back and look at it. So just some quick examples, if you go back and look at some of what the board was able to do before it was eliminated. The classic example is the Queechee case. There's no Queechee test in Act 250. It just says, you can't have an undue adverse effect on aesthetics. That's all that the statute says. And the board, through really working through the issues, created a very fair test to determine whether there's an aesthetic impact, a test that's stood the test of time, that's made its way into the Public Utility Commission Section 248 process. And if you look at that test, it's really a testament to what a board could do that is really fleshing out policy, not just basically kind of voting up or down on whether a project goes forward. Same thing with the growth criteria, very complicated issues of economics involved. Is a project going to have an adverse effect on services and the growth of a region and of neighboring towns? And the board was able to flesh that out and provide tests and ways of analyzing those issues that still exist today. And to use a natural resource example, necessary wildlife habitat had a little bit more detail in it, but the board, through precedent, has basically said this is what necessary wildlife habitat consists of, and this is how you mitigate and address these impacts. That was not in the statute. And I in our view, this is the type of guidance that you get from a board that is both, it's quasi-judicial, it's making a decision, but it's also administrative and able to really speak to the complicated, important policy issues in Act 250. So,
and sorry to interrupt. I
Yeah.
wanted to just, the environmental board disappeared shortly before I arrived in the legislature. So can you say a little more about that board? I mean, were they full-time members, or was it basically the sort of modest per diem that district commission appointees are paid? And so to what degree was it like a quote unquote professional full-time board versus a higher level, almost volunteer board, like the district? I would call the district commissions almost volunteer positions, right?
yeah, so it was a citizen board. It was known as a citizen board. There were several citizen boards at the time. It was really something that was, I think, very unique to Vermont. But it had a full-time chair. So the chair was full-time. There were 9 members. Chair was full-time, appointed by the governor. Importantly, and I think something that was not positive about how the board was structured, the chair served at the pleasure of the governor. So the chair could be removed, and he didn't need cause. So it did inject a political potential for politics, which stayed out of Act 250 for most of its early life. But at some point, that became an issue. But the chair was full-time and paid, and then the other members were per diem. So they would have to work through these cases, and I think it was the same $50 per diem that the commissioners got,
Okay.
which is another issue. I'm going to speak to that issue next, but
Sure.
But yeah, that's how it was set up.
And okay, great. And then did that chair have full-time legal resources
Yes.
available?
There was a robust legal staff at the board, a team of lawyers, and really excellent lawyers. Also, they worked closely with the Attorney General's office in the early days. There are a lot of cases that did go to the Supreme Court that helped make some of the precedent that I outlined. And so the board's decision got legal deference at the Supreme Court. So just to step back, so it's a de novo review. It's still a de novo review. So district commission makes a decision, and then now the appeal goes to environmental court, and it's called a de novo review. So you start all over again. So the district commission decision, it's not a record review of what the commission did. And it was the same way with the environmental board. There was a district commission decision. It was a de novo review. But then when the appeal went to the Supreme Court, it was a record review of what the board did. So the board lawyers did a great job of creating a record, developing the findings and facts, and making sure that the legal conclusions were supported by those findings. And then the AG's office, in those early decisions, they would argue before the Supreme Court and help shape a lot of that early precedent.
Okay. Senator McCormick. We still muted, sir.
Sorry. I just want to add that the district commissions, are quasi-judicial, And even though in my time, it was still it was a de novo review if there was an appeal. As the chair, you still wanted to do it right. You wanted to be to get make it as much like a court as you could in terms of fairness, rules of evidence, and so on. And I would occasionally, as chair, say, "Well, I'm going to rely on the quasi part of quasi judicial, and I'm doing the best I can, and I hope you can live with my decision." But usually, if there were any question at all, I would call a brief recess and get on the phone and call Montpelier. And the board's legal staff provided guidance to the non-professional. I had some law school after that, but I had not been to law school in those days. I had legal counsel as to what was the proper decision for me to make as chair. So they also provided that important service. Just wanted to add that.
So I don't want to keep, have you stuck on this piece, but one other piece of the puzzle I don't really understand, I don't know the history, is what was the rationale for terminating the environmental, well, was the environmental board just terminated, or it had authorities or responsibilities reduced and sort of withered away? How did it end?
We could do a whole seminar on this, but I'll try to be brief. So, and I should have written a book about it, and I don't know if anybody would read it. Maybe Senator McCormick might read it. But I was with the Water Resources Board. Alan said she'd read it. That's great.
I would read it. There's 3 copies right there.
All right, there you go. I know Senator Campion won't read it, but that's okay.
No, absolutely. I'd like a signed first edition.
All right. Well, maybe I'll get to work on that. But so I was with the Water Resources Board. I was the director of the Water Resources Board during that time. Like I said, there were a couple of citizen boards. There was a Water Resources Board, there was the Environmental Board, there was the Waste Facility Panel. And in my opinion, there was just a built up, all of the case precedent, all the good work that I described that the board did in creating policy guidance. I think over time, they made enough people angry. They issued decisions. And as I said, Act 250 did get politicized at some point. We went through some recessions, some ups and downs in the economy, and I think people wrongly, as they do sometimes, look to regulations as the scapegoat for economic, woes. And there was a lot of focus on Act 250 and the board, and a lot of the decisions that they issued, and there was a group of people, mostly in the business community, and Governor Douglas, who really wanted to move appeals to a court. And they wanted a lot of other changes to the process as well that didn't make it through. But at the end of the day, Governor Douglas, it was one of his main priorities to move appeals to the court, get rid of these citizen boards, transform the Environmental Board to the Natural Resources Board that doesn't hear appeals, and it's basically the NRB that you know today and that you've reviewed as chair of this committee. And that was the driver behind it. There were, just like today, actually, there was a lot of sort of negotiation and compromising going on. One of the parts of Act 250 that doesn't get discussed that much is that Act 250 was set up that not everybody could appeal. Only statutory parties and the applicant could appeal to the Vermont Supreme Court. So like environmental groups like VNRC, citizen groups couldn't get, if the Environmental Board issued a decision that a non-statutory party or the applicant didn't agree with, you couldn't go to the Supreme Court. So that was changed in 2004. That was hailed as one of the reasons for making the change, I think, from people who were not comfortable with getting rid of the board. But I think, Governor Douglas's desire to do that, some in the business community's desire to change the appellate structure, and the fact that now everyone could appeal. There's no limits on appeals to the environmental court, combined to, create a recipe where that change would occur. Everything that I'm laying out here today was said in 2002 to 2004 when the debate was occurring. All the concerns that VNRC has now were concerns that we had that might happen if we made this shift. And so now we're 16 years later, right? And so now it's enough time, we think, that you could look back and see the impact of what that decision was. And a lot of this was presented to the commission on Act 250, and Senator Campion and Senator McCormick heard this, a lot of the same testimony.
Okay. Thank you. So I know you had a part 2 you wanted to get to.
Yeah, so I'm going to go. So I would just note that I'm sorry.
No, I thought you
it's interesting.
talked about modernizations.
Yeah. So I would just note that the EO and one of the whereas clauses seems to nod to what I've been saying. One of the whereas clauses in the executive order says, when the Natural Resources Board replaced the Environmental Board in 2004, the Natural Resources Board did not retain its ability to compel consistent. Actually, that's not the one. It was basically that they didn't set policy, that they weren't able to set policy for the whole state. So, because I want to address the consistency issue, which we don't actually agree with. So the other issue with the process that we do think needs to be addressed is investment in the district commissions. We do agree that Act 250 is not the same as it was in 1970. When the early days of Act 250's permits were a few pages long. You might need a wastewater consultant to get the permit. They weren't nearly as complex as they are today. Now you're going to have several consultants working on an Act 250 permit, even a minor permit, which don't have hearings. You could have a traffic consultant, you could have an economic consultant, a planner, and you might need a lawyer. And we do think that the $50 per diem and the resources that have been provided for the district commissions over the years, they just haven't changed since 1970. And that's not a knock on this administration. This has been, this is a 30-year problem. This is not just a today problem. But we do think that we do need to provide some more resources, to the district commission. When I was NRB chair, I can say that we had a hard time attracting some people to district commissions because it's a lot of work, and you don't get paid very much. And I can tell you, there are, half a dozen occasions where I try to recruit people and I couldn't do it, or the governor really wanted to appoint someone and the person said no, because they were like, I respect the process. I don't have the time to put into it and give it what it deserves. So I do think that needs to be addressed. There are different ways to address this issue, that we think are different than the EO. And so I guess, I would say, we think that our first choice to address these issues were, one, to bring back a version of the environmental board. It doesn't have to be a citizen board, as you alluded to, Senator Bright, earlier. Perhaps that doesn't make sense to replicate in the 21st century, but maybe a smaller professional board that had people with varying degrees of experience and that were compensated and could hear appeals, but provide policy guidance in the decisions in the way that the old environmental board did. And then invest in the district commissions. I mean, surely they need to get compensated more, but more money for training, more money to make it worth it, so people will invest the time to be district commissioners. Ideas that came out during the commission on Act 250 and through the legislative debate over the last biennium were ideas of maybe district commissions could more easily hire their own experts if they were dealing with a complicated issue. They would have a fund of money so they could have an independent expert. The PUC does this sometimes. The old environmental board used to do this, so they could, the parties have their experts, but sometimes the tribunal could also hire their own expert. Have qualifications for district commissioners, so you're making sure that you're getting people who have backgrounds that are germane to Act 250. There's a number of things that you could do, but we believe that these are just our ideas, and I think these are very similar to the ideas and some of the recommendations in the commission on Act 250's report. But obviously we need to have more debate on these. On the EO specifically, I want to just point out that, you heard what it would do and how it would change the process. You also heard that it's similar to what the House Committee on Natural Resources and Fish and Wildlife actually voted out last year. But I want to point out that it's not the same as what the House Committee on Fish and Wildlife and Natural Resources voted out in really some important ways. What they had voted out did create a hybrid district commission professional board to hear major applications, but it vested more authority. The intent was clearly to have district commissioners decide what's a minor or major, which is a big deal. So deciding which applications would actually go to the board, the committee certainly wanted that authority to stay with the district commissions. 80% of applications are minors. So under the House committee proposal, 80% of Act 250 applications still would have been reviewed by district commissions. There are also safeguards for the independence of the board that would have made the board more independent than the environmental board was, as I discussed before. Under the old environmental board, the chair could be removed for any reason, not for cause, served at the pleasure of the governor. Here, there was a judicial nominating process for all the board members, and none of the board members could be removed unless there was cause. And there were some ethical provisions that were put into the proposal that provided further safeguards for the integrity of the process. And there was also something that we've talked about for years in the State House. There was provision for a scoping process at the beginning of Act 250. So for certain projects, the district commission would run before you entered the formal process, you would have informal meetings with the applicant, statutory parties, neighbors, people in the community to try to identify and work through issues. It was designed to be similar to the Section 248 process, where there's a notice of intent to file an application and an opportunity to comment on a project before it gets filed. And that was a process that would have been run at the district commission level. And all those things are not in the EO. And I just mentioned that because people have said, drawing comparisons between what's in the EO to what the House had passed last year, which VNRC did support. But it's not the same proposal in some very significant ways. And I just think that that's important, given as Senator Westman says, it's yes or no. Like you can't go into it and work on it and change the proposal. Really importantly, even with those differences that we think improves the EO proposal, it was pulled out of the bill before it even got to the House floor. There were significant concerns that were raised by legislators about the process changes, moving away from the district commissions, even with the safeguards I just mentioned. And it seems like the EO went the other way. Rather than addressing the concerns about changing the district commission process, it seemed to, as I said, move away from some of the safeguards. And we just don't think that that makes sense. If we're going to go forward, we need to listen to all the concerns that people raised last year and try to address them. I understand that it's probably frustrating because we had the Commission on Act 250 for 2 years and we had 2 years of debate, but it just clearly, what VNRC learned and saw was on this process issue, people just aren't, there are a lot of ideas. I just laid out a bunch of ideas. Matt before had some ideas. Other people are going to have ideas, and there's some merit to all of them, but we really need to continue to work on this because it's not ready. I just don't think any of the ideas are ready for these significant changes. And so our recommendation is to use this COVID time where it's difficult to really grind through legislation and create a formal working group to basically continue the work of the Commission on Act 250 on this issue and to grind through, do we agree on what the problem is? I just laid out from VNRC what we think the issues with the process are. Some people will agree with me, some people won't. But what is the problem and what are the ways to solve the problem? There does seem to be agreement that some change to Act 250 process does need to occur. But let's have a working group to basically identify what the options are and see what makes sense, what would solve the problem, and what there's support for. And maybe we can come back, next year when hopefully we'll be in person and we won't be virtual, and the pandemic will be emerged. We would have emerged from the pandemic, and we could see if we could move something forward. I mean, that seems to make the most sense to us. There's just two more things I really want to say before I'll stop talking and answer any questions you have. One is that I want to make it clear that VNRC never believed that the reason for these changes were because of inconsistencies in the Act 250 process. I mean, our reasons for what I just gave was that we lost the policy guidance that the board was able to give to the commissions, to the applicants, to the parties, to really bring Act 250 to life. But it wasn't that it was resulting in inconsistencies that were occurring with frequency throughout the commissions. We do think that Act 250 suffers for that lack of ability to really have guidance on how to interpret the criteria for all the commissions, not that the commissions are doing it inconsistently. And then secondly, we don't agree that until we could address these process issues, we shouldn't make any improvements to Act 250. One of the ideas that emerged was that, well, until we solve these process issues, we can't improve the forest criteria and some of the other criteria that have been worked on for years in the State House and were worked on by the Commission on Act 250, using the forest criteria in the bill from last year that the governor vetoed. I mean, I don't have to tell this committee how many years you worked on forest fragmentation, and we finally passed a bill that would have allowed Act 250 to address fragmentation. It had a rulemaking process, so there would be plenty of opportunity for people to argue about the details of its implementation. There would be a lot of guidance to applicants and the commissions and parties on how to implement that criteria. We don't usually have rules for criteria. That's one of the reasons we did it, was to address that concern. But I think you have to look at the work of the Commission on Act 250. There are some things we're ready to do, like forest protection. And there are some things that clearly we're not, like these process issues, even though there are still policy issues that need to be addressed. And so we think you could split these up and not have to wait to make any improvements to Act 250, until you solve every problem. And I think I'll stop there. I think those were the main points that I wanted to make.
Well, we're 0 for 3 on forest fragmentation, but we run aground and further downstream every time. So hopefully we'll make it all the way to the ocean the next round. Any questions for Mr. Groveman before we move on? I'm just mindful of the clock a little bit here. All right. Well, thank you. I
appreciate the time that you gave me and hearing me out. Yep.
Very, very helpful. And I see that Mr. Stanek has arrived while you were speaking. So I'd like to invite Mr. Stanek to join us. Thank you for coming back in. And we see your tile so far, but we can't hear your voice or see you yet. And there you are. Good morning, Ed. Thank you again. And
hello.
And now we have your voice. Thanks.
Okay.
And I know you had a busy morning already, so thank you for working us in.
Thank you. I have a
Can I just to make, sorry to interrupt, just so that you'll know what we're looking at the EO, and we're checking in with people out in the field who have experience with the district commissions and the process, and we're trying to assess whether or not this is a proposal that, in your experience, would improve or disimprove perhaps the operations of Act 250.
Thank you. For the record, my name is Ed Stanek, and I'm a resident of Barry City. I was employed for 32 years as an Act 250 district coordinator, and I thank the committee for this opportunity to testify. I have a 5 or 6 minute statement, and then I'd be glad to answer any questions the committee may have. Vermonters believe that governors and legislators make decisions after careful consideration of facts obtained from studies, reports, and input from lobbyists and Vermonters. Many decisions also rely upon the personal experiences of the governors and the legislators. Ideally, a mix of objective facts and personal experiences will result in sound decisions. But what is the effect on public policy when the decision maker's perspective on a personal experience is based upon a mistaken understanding of what actually took place? An example of such an unfortunate outcome can be found in Governor Phil Scott's personal experience with the Act 250 process almost 40 years ago, and how that experience tainted his positions as a state senator. It now drives his effort as a governor to change the Act 250 permit under the authority of an executive order. After graduating from UVM in 1980, Scott decided to open a motorcycle sales and repair shop in Morrisville. He teamed up with the H.A. Monash Corporation that offered to rent him space in a new building. Construction on the building had commenced prior to obtaining necessary state permits. Scott claims that unreasonable delays in obtaining an Act 250 permit subsequently forced him to abandon his business proposal, and he has been hell-bent on reforming Act 250 ever since. According to public records, Scott and Monash filed the required application for an Act 250 permit on May 17, 1983. The District Commission then processed application 6L0076-3 as a minor application on May 25th. The Commission circulated a draft permit and a notice indicating that any comments or requests for a hearing had to be made by June 9th of that year. As was and is still the common practice and required under statutory provisions and rules, the draft permit contained a condition that would incorporate the terms of an AEC, now known as the Agency of Natural Resources. It would incorporate the AEC permit on issues of water supply and waste disposal. Again, I said that the hearing notice set a June 9th response date for people that wanted to file comments or request a hearing. No one filed any request for a hearing or comments except for the ANC land use attorney, who reminded the applicants that the AEC permit and an electrical wiring permit was required. Thus, and here's the punchline, Phil Scott's experience with the Act 250 process was completed within 23 days. 23 days. Phil Scott was in and out of Act 250 in 1983. That's the public record. So what happened next? The District Commission waited the receipt of the AEC permit. That application was filed on May 11th of that year, and the state engineer sent a review letter to the applicants on May 23rd, 12 days later. Co-applicant Scott provided the final answers to the state engineer on October 21st that year, 5 months later. The AEC permit was issued 6 days later. Under the Act 250 rules, the applicants had the responsibility of providing the District Commission with a copy of that technical permit. Now remember, this was in the era before email. This was in the era before the electronic transmission of documents between state agencies. The rule required that the applicants provide a copy of that last piece of evidence. The 6L0076-3 public file reveals the applicants never provided the commission with that technical permit. That application for Act 250 permit remained pending in the district office until August 20th, 1987, when staff issued a memo noting the lack of progress on the pending application. That file contains no evidence of any inquiries or submittals from either co-applicant Scott or Monash after the filing of the application. The commission considered the application withdrawn on September 7, 1987, 4 years later, due to the inaction of the applicants to complete the record. Scott then took a job at the Monash Corporation when the effort to open the motorcycle shop was not completed, and then he became a principal with Du Bois Construction in Middlesex. But Scott's experience with the Act 250 process had a profound effect on the young businessman who was quoted in a February 27, 2017 Burlington Free Press article as saying, quote, "It definitely changed my life," unquote. Scott first ran for the state Senate in 2000, and his Act 250 tale of woe was an essential part of his stump speech and continued to shape his political career during campaigns for lieutenant governor and governor. I contacted the governor directly twice about the contradictions between the content of his stump speech and the file. The first time was during the fall of 2014, following a forum for lieutenant governor candidates, and Phil and I exchanged voicemails. The second contact was through written communications in May of 2018. And at that time, he wrote back, quote, "If indeed the application failed because of delays in the inability of the lead applicant to complete the application process, I believe this suggests we need to determine if the system we have in place is sufficient," unquote. So what is the takeaway from this glimpse into the development of the governor's attitude towards Act 250? The misplaced bitterness of a young businessman became a pillar upon which a political career has been built and continues to this day. Scott now attempts to drastically alter the administration of Act 250 by means of an executive order without any evidence of the quote unquote problems that the EO purports to solve. I have voted for Phil Scott. I applaud his leadership in guiding us through the COVID pandemic. But when it comes to a clear and objective understanding of the Act 250 process, his policies are inherently flawed. The governor's policies do nothing. They do nothing to ensure that Act 250 will be strengthened in order to adequately address foreseeable 21st century growth pressures on our dwindling finite natural resources. At least one house of the General Assembly needs to pass a resolution pursuant to the duly enacted provisions of 3 VSA 2002 subsection B and disapprove the governor's executive order that would destroy the time-tested, decentralized, and publicly accessible decision-making process of the Act 250 district commissions. Just 2 more minutes here, if you bear with me, senators. I have great difficulty commenting on the merits of the executive order. To do so lends credibility to the governor's illegitimate use of the provisions of 3 VSA Chapter 41 and violates my personal sense of ethics. But make no mistake about it, by means of 4 pieces of paper and his signature, the governor proposes to complete the dismantling of Act 250, which began in 2004 with the elimination of the Environmental Board. Not only will the decentralized district commission process be destroyed, along with accessible and public participation will also be terminated. You know, I want to note too that legislation in 2004, I won't go into great detail, it's in the legislative records, but that bill in 2004, which eliminated the Environmental Board, you know who one of the primary sponsors of that was? Senator Phil Scott. And if you read his executive order right now, he pins the problem of alleged inconsistencies on the elimination of the board and the creation of the Natural Resources Board. But he was an advocate for that. So one might say that his chickens are coming home to roost now. What is the basis for this executive branch action through the executive order? There are 6 vague goals stated in paragraph 1 on page 2 of the executive order. But what proof or case studies to support those 6 goals? The Legislative Study Committee for Act 250, to its enormous credit, produced a great report with findings of fact and conclusions or recommendations. There's no such document from the executive branch. Rather, it's based on a brazen political power and the governor's imagined understandings of the Act 250 process. 3 final comments specific to the EO. Where is the cost analysis? Where is the cost analysis of how much this is going to cost? Last year, there was a similar proposal, as John Grogman has pointed out, before the House. I testified before the House Ways and Means Committee. Making a long story short, and I can provide the Senate committee with my testimony from last year, but based upon statistics available from the NRB itself, it was estimated that with the change, and it's similar with the change being proposed now, it would be an increase of about $24,000 for every case that goes to an Act 250 hearing, now done by district commissions, an increase of around $24,000 for each case. Where is the revenue stream that's going to pay for this proposal by the governor. When it was before the House last year, the estimates were $600,000 to $700,000. I thought it was going to be closer to $1 million when you factored in other costs, such as increased staffing and what have you. Where is the cost analysis? Where's this money coming from? I didn't see this in the governor's budget address of a few days ago. Secondly, this proposal is going to be chaos to administer. It's finally going to bring home what the Supreme Court of Vermont warned against, which is Act 250 should not become an administrative nightmare. The executive order guarantees the nightmare. This ridiculous Mickey Mouse of people around the state filing applications in district offices, then the applications go to the NRB headquarters, then things happen there inside of a black box. It's ridiculous. It's not user-friendly. It's not customer-friendly. Finally, on this topic of consistency, the Act 250 process has been the subject of malignant neglect by Phil Scott's NRB for the last several years. There's been woefully inadequate training of commission members, inadequate training of staff. Consistency was ensured for many years through adequate training. This allegation of inconsistency ignores the fact that, number one, each case turns on its own factual merits, both before the district commissions and also when a jurisdictional opinion is issued. So finally, I personally find it shameful that the governor proposes and that the General Assembly may allow the destruction of an environmental regulatory process that for 50 years, I think everyone agrees, has resulted in the Vermont that we all see and love today. It's just simply going to be eliminated by 4 pieces of paper and a signature without the proper process of going before the legislative committees for consideration of the merits through an appropriate bill. Thank you. I think I went on more than 7 minutes, but I'd be glad to answer any questions.
Thank you. I'm looking to see if there are any questions from members of the committee or comments. All right. I'll just speak for myself. I'm a little uncomfortable with some of the sort of personal interpretations of the governor's thinking on some of these things, but it is, the facts are the facts in terms of the timing of that application history you were talking about. And so I think that was probably new information for everyone on the committee. The question of, and you've provided a good segue for, we've asked the NRB to visit with us today, in part to address costs. Before we go on, I did want to make sure I heard correctly your comments on costs. The $24,000 per case, I'm sorry, so can you compare a case carried out at the district commission level versus a case moved to the NRB, the 3+2 proposed structure? Is that the $24,000 increase, or I didn't quite follow?
The proposal that came out of the House was close to the proposal in the executive order. But as I recall, the proposal that came out of the House did not incorporate, I might be wrong about this, but I don't think it included having the 2 representatives of the district commission. The calculations that were done to Ways and Means was the estimated cost to pay the salaries of the new full 3 members on the new board. Plus, I think there was 1 new attorney. So there was a bottom line number. And then we calculated the number of cases which actually go to hearing in that calendar year, which is now 2 years ago. And the simple division came up with $24,000 for each hearing, which is now, we all know, done by the district commission members who get a walloping $50, I guess it's now $100 per day per diem.
Right. So so that's helpful to understand the 24. Can you, just so we have kind of an apples to apples comparison, the same case carried out start to finish at the district commission level, do you have a guesstimate as to what that would cost? I mean, it's going to be more than the $50 per diems, because they have a full-time technical support available to them. So we should probably roll that overhead in. But so I'm not asking you to be precise, but I'm just trying to have a ballpark sense.
I don't have such a number. I think that burden of proof is upon the administration to produce apples to apples. The
Okay.
Ways and Means Committee didn't ask for that. The Ways and Means Committee in the House was concerned with how's this going to be funded? Where's the revenue coming from?
Okay, all right. Thank you very much for your careful research and informing the committee this morning. If there are not any, I don't see any hands. Okay, so thank you, Mr. Stanek. With that, I'd like to turn to the Natural Resources Board. We have the Chair Snelling and Mr. Boble with us. The request for information that I sent over to the NRB was around the financial aspects, but Chair Snelling and Mr. Boble, I would like to follow up on the financials, but we're also open to hearing, there's been quite a lot of testimony this morning, and maybe you'll want to respond to some of that as well.
Mr. Chair, if I may, Diane Snelling, Chair of the Natural Resources Board, Act 250. I would like to just present the numbers as the costs as requested and keep my testimony constrained to that information.
Okay, great. That's all we asked for. So
and I know we were in to testify previously, so I don't know that we have anything else new to offer to the committee for consideration.
Sure.
So
okay, well, thank you. I just wanted to make sure that if you heard something that you felt invited to respond, that's all.
I heard a lot of things that I might respond to, Mr. Chair, but I choose not to at this time. Thank you.
Okay. All right. Okay.
I hope that you have been forwarded the copy of the testimony that I sent to Jude. In any case, what I've done is just take your questions, and I sort of accumulated questions or consolidated questions 1 through 3 about the costs of the new structure, the cost of the 2 new full-time board members, and the cost of additional staff support. The total estimated cost is $500,000, with personnel costs, including benefits, estimated at $350,000, and operating costs estimated at $149,000. So the impact.
Sorry, Madam Chair.
Yeah.
Pardon me. For committee members and anyone watching on YouTube, this document is posted to the committee's webpage. Thank you.
Thank you. Sorry. Yeah. Your next question was, what impact will there be to the ongoing operations of the district offices? And we're not anticipating any financial impact. Next question was, are there other financial implications that the committee should be aware of? And has the NRB Act 250 contemplated any means of funding the new structure on an ongoing basis? The committee should be aware that the governor has included $500,000 in his recommended budget for FY22. In addition, after many difficult years with unpredictable special fund revenues, the governor has also added $1 million to his recommendation to fill the current NRB Act 250 deficit of negative $647,389 and provide some additional resources to avoid future deficits. These changes came about as a direct result of the governor's support for the new NRB Act 250 structure and our internal budget work with finance and management regarding the deficit.
Okay, thank you. So,
thank you.
you're reminding me of something I think I've heard you allude to before, but I've forgotten, and that is, so are you saying that the 647,389, that basically you're operating at a deficit and the administration backfills so that you, in essence, you kind of owe that to the administration, but they provide you with the funds? Is that the right? Is that
I believe they have filled the deficit. They filled the deficit, and that leaves $400,000 as an additional resource against a future deficit. We have no way, as I've told you in the past, to predict the revenues from projects. And we are heavily dependent on the fees from projects for our revenues. In the last several years, those revenues have not met expectations. So, we could not continue to carry a deficit. Let's just put it that way.
Sure. Okay. Well, so this would leave you plus 352 and change, kind of a operating reserve maybe, or something like that.
I just think it's really important for you to know that it is in the governor's budget, and the governor has made an extraordinary effort, in my opinion, to make sure that this goes forward and it is funded sufficiently.
Okay. For the long term, so since I understand, this isn't a criticism, I'm just trying to understand the math. If you've been operating at a deficit and this clears that up and leaves you with a reserve of 352 or so, that it would seem as though you might well end up back in deficit territory again. Are you proposing anything for the long term?
Chair, we have discussed this in the past, and I believe that I have made it quite clear that there needs to be a discussion about the sustainability of our current funding.
Okay. Well, we're actually trying to understand it in order to be helpful.
No, I understand that. I'm just saying, it's a big conversation, and right. I do not believe it's a matter of raising fees. I don't think that's the solution. Okay. So I think there has to be another look at exactly what the expectations are. And I would say my recommendation was to consider increasing the general fund portion of our budget. Right. As an example of where we have been underfunded, perhaps in the past.
Okay, well, that makes sense. Thank you. I mean, so it not necessarily impacting fees, focus on the appropriation that is your base budget. That sounds like right. Okay, well, that's helpful.
And I might just add to that for the committee's understanding is that I just remind you that 70 up to 73% of our projects are finished in 60 days or less. And the fee for $1 million project is $6,650. And that goes up by the million to 15 million. And I'm just trying to put these things in perspective going forward with what the degree of general fund that would have to be added. And it's less than 1%. And I forget the exact calculation, but my point is, in terms of the public support of environmental protection, seems to me it could be easily justified by a total of $1 million in general fund, in addition to the special fund with the fees.
Okay.
But that's a proposal for discussion and not a conclusion.
Sure. Right. We're just trying to check in on some details at the moment. I think everyone knows there's a much bigger discussion to be had. Just to make sure I caught that right, did you say a $1 million project would have an Act 250 fee of $6,652?
Yes, $650. It's 1,000 times $6.50.
Okay, and does that, out of that fee, do you remit a portion of that to A&R? Or
no, A&R charges an additional 75 cents per thousand that we collect and return to them, which is about $200,000.
Okay, great. Thank you very much for helping us get the numbers straight. Any committee questions for Chair Snelling? Okay. Seeing none, then
thank you very much, Mr. Chair and committee.
Yeah,
pleasure to be here.
Thank you, Madam Chair, for joining us again. And I see Mr. Bobles on the well. I don't know if he had anything to contribute. I figure you're the lead. If you wanted to call on him, he would chip in. Do you have anything you want to add, or is Chair Snelling taking care of everything?
Thank you, Senator Bray, and good morning to the committee. No, I don't have anything to add at this time. I'm around should any questions arise from the committee.
Okay, thanks again for making yourself available.
Sure.
With that, then I'd like to turn to the committee's counsel, Ms. Chakowski.
Good morning.
All right. And good morning. So I think my sense, based on the testimony we've heard this morning, which, well, I won't characterize all the testimony, that my sense of where the committee has informal conversations over the last 2 weeks on this is that the committee sees the executive order as a problematic way of addressing genuine shared concerns about improving Act 250. Probably the most succinct thing I heard about the whole thing was from Senator Westman, who pointed out it's a take it or leave it option, which is a hard place for us as legislators to work from, not a very productive venue for sorting things out and making improvements. So my sense is that the committee is interested in, and so here I want to, this is a genuine question to all of us, to disapprove of the executive order and to invite the administration and others to participate in a longer legislative conversation to address some of the issues that clearly are lurking underneath the hood of what the executive order brings up and puts on the table.
That's accurate.
So, okay. Anyone else want to say anything about sort of the general sense of where we are? Okay. Because today's testimony confirms, I think, that shared sense from prior meetings. I had asked, for the sake of efficiency, Ms. Chakowski to prepare a resolution in the right format for us to issue a disapproval. So I gave her language, she helped me sort things out. And so it's just a draft. I'd like to put it on the table for the committee to look at together and see if this is something that expresses the thinking of this committee. So Ms. Chakowski, if you could share the screen and show us a draft. And just for the sake of completeness, had we wanted to approve, we don't need to say anything. So there's no draft. I didn't ask for a draft approving. The process is only a draft if we choose to disapprove. So if you could walk us through this draft language, that would be helpful, please.
Sure. For the record, Ellen Tchaikovsky, Office of Legislative Counsel. All right, can you see my shared screen?
Yes, thank you.
Okay, so this is the draft resolution. Senate resolution relating to disapproving of Executive Order 2-21. Whereas on January 14th, 2021, the governor signed Executive Order 0221, reorganizing the Natural Resources Board and its district commissions. And whereas, according to the executive order, effective April 15th, 2021, a professional natural resources board would decide major permit applications with assistance from 2 district commissioners from the district where the project is located. And whereas the Senate Committee on Natural Resources and Energy has taken testimony and public comment concerning this executive order. And whereas the Senate agrees with the governor that it is to the benefit of the state of Vermont to maximize natural resources protections, enable well-planned growth, increase predictability, and reduce redundancy with other state regulatory programs. It finds complexity and possible unintended consequences that must be analyzed and addressed to achieve these goals. And whereas the Senate believes the best mechanism to both resolve these complexities and unintended consequences and to explore in depth the options for reorganizing the Natural Resources Board is to use the standing committee process with resulting opportunity for enhanced research, analysis, and public participation. And whereas the Senate is committed to working cooperatively with the administration to produce legislation that will achieve our shared goals of updating the Act 250 process. And whereas a part of this process, the Senate Committee on Natural Resources and Energy looks forward to reviewing and taking testimony on the administration's complete proposal for changing the Act 250 permit process. Now therefore be it resolved by the Senate that the Senate, pursuant to 3 VSA Section 2002, disapproves of Executive Order 2-21, and be it further resolved that the Senate invites the administration to bring forward draft legislation to optimize the Act 250 permit and appeals process. And be it further resolved that the Secretary of the Senate be directed to send a copy of this resolution to Governor Philip B. Scott.
Great, thank you for walking us through. So committee members, Senator McCormick, I see your hand up. But we
Thank you,
don't
Mr.
hear
Chairman.
yet.
On the actual merits, I think this is just fine. I have a procedural question. We had not fully resolved the question of whether we need one house or two houses. And this is a Senate resolution. If we were to pass this, and then if it were to be decided that we do need two houses, and the House passed a House resolution worded the same, would that, usually to pass something out of the legislature, it has to be the same piece of legislation passed by both houses. So should this be a joint Senate resolution rather than a Senate resolution?
Sure. Well, that's it. I'll take it. Council has the legal facts. My request to council was to follow the letter of the law as we currently understand it, and to write a resolution. We only speak for ourselves. And I know that, what the House does or does not choose to do will be their choice as an independent body, but that we are silent on any constitutional issues, and we're just focusing on the merits of the testimony we've heard of in terms of impacts on Act 250 in our document.
Yeah, but I mean, I'm not prejudging the House or having us try to decide it. We do have such a thing as a joint resolution. We would pass it and then send it to the House for their judgment. And if they concurred, then you would have passed it by both houses. And that may or may not be necessary. It may well be. I fully understand that the law is that we only need one, but the question has been raised as to whether that law is constitutional. And I'm not saying it's not. I'm saying that's a question we haven't resolved.
Right. Well, council, please go ahead.
Sure. So the statute, 3 VSA Section 2002, is a long-standing statute. While there may be ongoing litigation, no one has any way of knowing in what way that litigation will proceed. And there is a pretty high burden to challenging a constitutionality of a statute. So at the moment, 2002 is a constitutional statute. So the process is laid out in there. It only requires one body to act.
Okay, that is a good answer to my question. Thank you. Thank you.
Right.
Thank you, Mr. Chairman.
Thank you, Senator McCormick, for bringing it up. I don't mean to dismiss it in any way, but just that I had asked council to hew very closely to the statute as it's currently written.
Yeah, no, I don't feel that my question was dismissed. I feel that it was answered.
Okay, thank you. Senator Campion.
Thanks, Mr. Chair. I guess another procedural question. So are you thinking we would vote on this on Tuesday?
If the language is sufficient, if people are satisfied with this, I mean, it's up, we have time to make edits in the interest of continuity of our work on things. If we can finish our work today on it, I'll be looking for a motion to move this resolution out of committee today. So this is really a moment where if people have language changes they're interested in making, we can discuss them right now.
My only, if I may continue,
Yes, please.
my only thought on a vote today is it's similar to a bill. This is the first time the public and others are seeing this draft. My good friend and chair of finance, Senator Cummings, I can't remember the wording she would use, but it was always, let's put this out there, let's get it on the calendar for a vote. And I just wonder if doing it today makes sense or doing it Tuesday. So that's something for the chair, I guess, to answer. Given that it's new language for most, for everybody watching.
Sure. My sense though is this is the committee speaking on behalf of the committee to our colleagues based on what we've learned. I don't know that personally, I don't know what we would hear in any further testimony.
Okay.
To change the resolution, which honestly, I'll just be quite candid about it. In working with council, tried to be polite, respectful, lay out some agreement on goals, and lay out an interest in being able to work on this and in the normal legislative process, because the testimony has repeatedly shown us that that there are possible negative unintended consequences that none of us would like to see. And so then we invite the administration to work with us in the normal way. So I don't know that any testimony for me personally, and if others feel differently, then please do speak up, that any additional testimony would change my assessment of what we might say at this point.
That's a very good point. I appreciate that, Mr. Chair. So with that, I would like to move that this resolution as written passes.
Okay. Before we vote, I see both Senator McCormick, your hand is up. I don't know if that's from before or you have another, like to offer a couple more thoughts. Senator McCormick.
Sorry, Mr. Chairman. I have a voicemail coming in on a loudspeaker, so maybe I should stay mute for a second and come
Okay.
back
Well,
in a second.
Okay.
I apologize. I can't stop it.
Okay, we'll turn to council has something to share with us, and then we'll go to Senator McDonald.
Sure, quickly. So I don't think I've discussed at length in this committee that in 2017, I know I mentioned this, but there were 3 reorganization executive orders issued by the governor. And just as a reminder, in that instance, one of the reorganizations, the merger of the Liquor and Lottery Board, was disapproved by a resolution by the House. Then the creation or reorganization of the Agency of Economic Opportunity, that was disapproved by a resolution by the Senate. And then the other executive order was to create the Agency of Digital Services, and that did go into effect. In drafting this resolution, I did review, as well as I do believe Senator Bray also reviewed the language of those two disapproval resolutions to get a sort of general sense of what they contain, some of the similar provisions as Senator Bray just mentioned. So this is a fairly short document, but it does follow a similar structure to the prior single body disapproval resolutions that have happened in the last 4 years.
Thank you.
Senator
Mr. Chairman,
Senator
I'm ready
McDonald.
now.
Okay, back to Senator McCormick, then Senator McDonald.
Thank you, Mr. Chairman. I apologize for that. It was a loudspeaker. I couldn't turn it off. And he was long-winded. I was thinking about the, hold on. The, and you notice I've come into my closet to get away from the speaker. If we were to vote this today, it would be in the notice calendar on Tuesday and would be up for consideration by the Senate on Wednesday. And this is a matter that's gotten enough press that I think it would become public information fairly quickly that if we voted it out. So I think there is plenty of time. I don't think we'd be rushing it if we put it out today.
Okay.
So.
Thank you very much. Senator McDonald?
Mr. Chair, I'm perfectly satisfied to vote yes in favor of the motion. The provision for executive orders is a terrific opportunity for people who have worked together and reached consensus to streamline the lawmaking process. I was quite frankly surprised to see the executive order come out without having the three parties that have to all agree to make law, without those three parties having reached a consensus. And that's why this is a take it or leave it vote. And I would vote to leave it and hope the next time Governor proposes an executive order that it's because a consensus has been reached. But so I'm ready to vote.
Okay, right. And thank you, Senator McCormick, for reminding me. So we will have a long weekend plus notice plus a floor day. So a vote is, if it proceeds in the ordinary timing, 5 days off. So, and I'm sure there'll be opportunities to talk about it again in caucus, and I'll be happy to go to the minority caucus as well and speak with folks in there as well to make sure everyone in the Senate feels fully informed, gets a chance to ask all the questions. All right, well, there's a motion on the table to adopt the resolution. Is there any further discussion? All right, then I would ask the clerk to call the roll, please.
1 minute here. Let's see. Senator McDonald.
Yes.
Senator McCormick.
Yes.
Senator Campion. Yes. Senator Westman.
Yes.
Senator Bray.
Yes. Okay. Thank you, committee, for I think handling a sensitive matter in a with finesse. So I know that we covered a lot of territory in order to make sure we had enough testimony to be well enough informed to respond, I think, responsibly to the executive order. So with that, we'll send this out. And personally, I want to emphasize the invitation to all parties that's in there, including the administration, to continue to engage with us on the issue, which the executive order is highlighted. So that's a favor to everyone, that there are issues to be worked on within Act 250.
Mr. Chair.
Yes, please, Senator Westman.
There are a lot of people that would like to testify on this issue. and way beyond the number of people that we have had in. And so I look forward in the future when we take this up, where it's a bill, that we get a chance to hear from them.
Great. And I think if there's anything that's come up over and over again for me on Act 250 issues generally, is one of the most helpful things that I think is too often not part of the conversation is a precise definition of the problem. Because if we don't define the problem we're tackling, then it's hard to make sure we have the right testimony from the right people to make sure that we're well enough informed to make a good decision at the end of that testimony. It just seems as though for some people, there's kind of an Act 250 hangover, and they feel they're not happy with it, but what they're not happy with is sometimes not clearly expressed in what comes forward to the legislature, and it makes it hard to come up with a satisfactory solution or improvement. So I would invite every member of the committee to be thinking about, maybe we start a list of what you think is most amongst the things going on. I think there's a moose outside Senator Westman's window.
It's a deer.
A
It's a young deer.
I can't see. Oh, a mooseling, also known as a deer. I'm
It's
a
a mama
wildlife
deer.
biologist. Yeah.
Beautiful.
Oh.
Rich, thank you so
there
much.
they both are.
Yeah, it's the mama and the baby, right under my bird feeders.
It's great.
If people would, start a list prioritizing concerns based on, and we have a lot of experience with Act 250 in this room. Maybe what we should start is a list and see if we could prioritize. We're not going to end up with a comprehensive Act 250 bill that addresses 27 things. I think this is not, in the remote session world, not a task well suited to Zoom meetings, etc. But I think we can prioritize and do some limited but important work on Act 250. So I would just ask people to start thinking some about what rises to the top of your list of opportunities to make an improvement, or an enhancement to something we've missed on, or an improvement to something that's particularly problematic. Okay.
It's hard to concentrate, Mr. Chairman, with the deer.
Yes. All right.
Beautiful.
Really great.
So next week we'll be doing some more work on weatherization. I think there will be, to the relief of all of us, an actual bill in the room that we'll use as the canvas to write a new bill on. I look forward to doing that work with all of you. So we are adjourning a little early, which is probably a relief to everyone by Friday, and we have floor at 11:30. So if there's no further business, we are adjourned. Thank you, everyone.